My name is Louis Brown, and I serve as Associate Director of the Center for Law and the Human Person here at Catholic Law. Also, I've served as a law lecturer the last couple years, and it's my pleasure to introduce Jeff Pojanowski, who will chair the panel Doctrine and Development in Theology and Law, a topic of great professional interest, I think, to all of us in this moment in history. Jeff Pojanowski is the Biolchini Family Professor of Law at Notre Dame Law School. He teaches and writes in the areas of administrative law, jurisprudence, legal interpretation, and torts. He serves as co-editor of the American Journal of Jurisprudence. Jeff earned his undergraduate degree in public policy with highest honors from Princeton University and his law degree, magna cum laude, from Harvard Law School. He served as a law clerk to then Judge John Roberts of the U.S. Circuit Court of Appeals for the District of Columbia, and then as law clerk to Justice Anthony Kennedy on the U.S. Supreme Court. Big difference, you're right. Prior to law, teaching full-time, he practiced law here in D.C. It has been a pleasure to get to know Jeff last night at the dinner, and please welcome me in welcoming Jeff.
Thank you, everyone, for being here today. This is a great occasion to talk about Newman and to celebrate our good friend, Professor Mark DiGirolamo. I'm chairing the panel. I also get to talk. I will go last. We'll go in alphabetical order besides me. We'll start with Professor Jennifer Frey and then Father Juan Vélez. I will give introductions for both, and then we'll go from there. So Dr. Jennifer Frey is the Dean of the Honors College at the University of Tulsa, with a secondary appointment as Professor of Philosophy in the Department of Philosophy and Religion there. She earned her PhD in philosophy at the University of Pittsburgh, and before moving to Tulsa, she was an Associate Professor of Philosophy at the University of South Carolina, where she was also a Peter and Bonnie McCausland Faculty Fellow in the College of Arts and Sciences. She is also a Faculty Fellow here at Catholic's Institute for Human Ecology. Her academic research focuses primarily on moral psychology and virtue. Her current projects include a volume titled Practical Truth, written with her husband and colleague Christopher Frey, as well as a volume titled Practical Wisdom under contract with Oxford University Press. Among many other things, she also hosts a philosophy, theology, and literature podcast called Sacred and Profane Love, which is the source of the sticker on my office door that proclaims Aquinas is for lovers. To my right is Father Juan Vélez. Father Vélez is a priest of the Prelature of Opus Dei. He holds a doctorate in dogmatic theology from the University of Navarra. There he studied under Professor Jose Morales and wrote his doctoral thesis on St. John Henry Newman's eschatology. That was only the beginning of Father Vélez's work on Newman. He's the author of the 2012 book Passion for Truth, The Life of John Henry Newman. He's also edited and contributed to the volume A Guide to John Henry Newman, His Life and Thought, with the Catholic University Press of America, published in 2022, and is available for purchase outside. He's also published widely in theology and medical ethics. Father Vélez also has a medical degree from the University of Navarra and was previously a board-certified physician in internal medicine. So it is fair to say he's a doctor of the body, mind, and soul. So we will start with Professor Frey, and then Father Vélez, and then myself, and then we can open it up to questions amongst ourselves and with the crowd.
Okay, terrific. Thanks so much, and especially thanks to Mark and Elizabeth for inviting me. It's always a pleasure to be at the Catholic University of America. I'm going to begin with Max Weber, and hopefully it will be clear why as we progress. So in 1917, Max Weber was invited by a group of university students in Munich to launch a lecture series on intellectual work as a vocation. And in this lecture, he famously advances an account of scholarship that is very much still with us today. So Weber articulates his remarks on scholarship, Wissenschaft, within his more general diagnosis of modernity as a period of disenchantment, right? So Weber claims that all things in theory can be mastered through calculation, right? And this means the disenchantment of the world. Now, for those of you who might not be familiar with the Weberian concept of disenchantment, it's constitutive of his concept that we have a kind of Baconian mastery or rational control over nature and thereby our own lives. But I also want to note that enchantment, right, the German, a literal translation is like de-magicification, right? The German word is actually magic. And whatever is magical on this view turns out to be whatever just can't be shoehorned into the ontologies, epistemologies, and calculative rationalities of the natural sciences, including, of course, the nascent social sciences. And the university as an institution sort of must, Weber argues, inevitably reflect this basic condition of modernity. That is to say, the condition of disenchantment. And it's within this larger framework that Weber presents, just as a descriptive fact, an account of scholarship as specialized expertise, right? And here I'm just quoting him. We can feel sure that we have achieved something of real scholarly value only if we have specialized to the utmost degree. We must resign ourselves to knowing that, at best, we have supplied useful questions to the expert, questions which may not have occurred to him so easily from within his own specialized perspective. So Weber argues that the scholar is a professional expert who labors to increase our repository of objective facts. And let's not forget that Weber is also the one who saddles us with the fact-value dichotomy. Weber is emphatic that, this is another quote, it is not a gift of grace, with seers and prophets dispensing holy objects and revelations, nor a part of sages and philosophers' meditations on the meaning of life. Like, all of that is ridiculous from the perspective of real Wissenschaft. Real Wissenschaft leaves unasked questions of meaning and value. Those should be left to the prophets and the priests, and neither of them have any place in a university. I also think it's worth noting that Weber further yokes the notion of scholarly work to a technical notion of rational progress that is both incremental and without end. So the scholar works towards a future in which his own work is necessarily undermined by the progress of others. So this sort of knowledge that scholarship produces is actually destined to be irrelevant. This is a feature and not a bug for Weber. So here I'm quoting him again. In a very specific sense, scholarship, unlike any other cultural endeavor, is dedicated to its own obsolescence. Every scholarly work that accomplishes its goal produces new questions, new knowledge. It wants to be surpassed and left behind. So we see an idea of progress in knowledge, or new knowledge, as one in which future knowledge does not build on the foundation of the past, but actually makes it totally irrelevant. Tradition, obviously, on this view, carries no special authority or value. It's also essential to this definition of progress that it has no ultimate horizon beyond itself. So Weber does not believe in transcendent norms like truth, beauty, or goodness, and he certainly has no normative conception of wisdom governing the scholar's work. So this raises the question, okay, well, what is the meaning or value of scholarly work then? And Weber's answer is quite interesting, and it has three parts. First, scholarship gives us more techniques for calculating and controlling life, including human behavior. Second, scholarship gives us methods of thinking, right? Critical tools of the trade and the training that we need to use them. And third, scholarship gives clarity about the means to whatever ends we have adopted. What scholarship emphatically does not and must not do, according to Weber, is tell us which ends we ought to pursue. To render a judgment of value would be demagoguery and abuse of power. Scholarship can in principle have nothing to say about ultimate ends. This, again, is the inevitable result of the forces of disenchantment. Now, one question that presents itself here is, all right, well, what sort of disciplines can count as Wissenschaft then? Weber is very clear that theology is totally out, right? It violates the terms of modernity, and therefore it can be no part of a modern university. But like, if we're being honest with ourselves, I think philosophy and other humanistic disciplines are likely going to fare poorly on this model as well, and in fact have fared poorly. Weber leaves us a model of scholarship and university teaching and learning in which judgments of value not only have no place, but actually make no sense. However, lying behind this account of scholarship is a judgment, of course, about what counts as rational knowledge that seems to leave not just theological knowledge, but philosophical knowledge in a marginalized and questionable position. So here's like my bold claim. We're all basically forced to be Weberians now in the academy, just the way, if you look at the way that our universities are structured. So universities now understand themselves in the knowledge production business, where knowledge production is understood in terms of discrete, measurable, isolated outputs of, quote, new knowledge. In order to get tenure or promotion, you have to focus on publishing in academic venues, which means that you do actually have to be a hyper-specialist. The tenure and promotion process is all but designed to ensure that we remain in disciplinary silos. Most of us have no idea what on earth is going on in other departments because we have no incentive to know and nothing but bureaucratic obstacles standing in the way of finding out. Even undergraduate education is now merely a prologue to specialization and professionalization, since its measure of success is all too often its effectiveness in preparing students for admission to graduate or professional schools, and it is in fact evaluated on those terms. I'm a dean now, so I know this in an especially intimate way. I think this is an especially poor model for the discipline of philosophy, my discipline, which in the contemporary university is just one discipline alongside others with no special job or function. We philosophers are basically the monks of the academy, historically important, but now a weird remnant of a time mostly forgotten, it being mostly unclear why we are still around. Long gone are the days when we philosophers ourselves speak of wisdom or have any kind of justification for what we're doing. We produce our research outputs like anyone else and hope that by the gratuitous grace of those with institutional power over us, we can be allowed to carry on with our intellectual labors, despite the fact that our majors have dwindled to almost nothing and our contribution to research dollars are relatively pathetic. Okay, now I'm going to talk about Newman. I think we find the resources for constructing an alternative model in Newman's idea of a university. Newman's idea of a university was written in 1852, 12 years before Weber was even born. It's a series of lectures for a Catholic university that Newman himself was newly in charge in, an endeavor that ultimately failed. In these lectures, Newman advocates for the idea of a university is focused primarily on teaching the liberal arts, with the understanding that liberal arts are those arts undertaken for their own sake, and that bring about habits of mind that prepare young students to be free in an interior sense, right? Free to know what is true, good, and beautiful, and to live your life accordingly. For Newman, a university is concerned first and foremost not with the advancement of knowledge, but its diffusion and extension. One thing to note right off the bat, in order to stave off confusion, is that Newman's definition of a university has essentially nothing to do with Christianity or the church. So the university, as he defines it, is simply an institution dedicated to seeking and teaching universal knowledge. That's the definition. Newman is most concerned that the university be a place where the whole of liberal knowledge is represented. It is not simply that no part of this knowledge can be left out, but that this knowledge must form a whole or be comprehended as a unity. The unity of knowledge functions like a regulative ideal for Newman, much as it did for Humboldt, actually, in his original vision of the modern research university in Berlin. Like Weber, Newman speaks of knowledge in terms of facts, but unlike Weber, he thinks that we can know facts beyond what strictly empirical methods might deliver. He thinks we can have knowledge through intuition, through testimony, through abstract reasoning, etc. By whatever illicit means we come by such knowledge, it will fit into a larger system or unified account of what can be known, which he is happy to just call reality. So truth is not simply grasping of facts, but understanding facts in relation to one another as a totality, as part of a comprehensive system of knowledge. Here Newman draws on the concept of aletheia in Aristotle, a deeper truth that goes beyond mere assertoric truth. This kind of deep sense truth carries with it something like a concept of progress. It's just very different from Weber's. So now I'll quote Newman, "As we deal with some huge structure of many parts and sides, the mind goes round about it, noting down first one thing, then another, at it as it may, and viewing it under different aspects. by way of making progress towards mastering the whole. So by degrees and circuitous advance does it rise aloft and subject to itself a knowledge of that universe into which it has been born. So Newman's idea of progress, by contrast with Weber's, is the idea of making progress in seeing how the parts of truth relate to a greater whole of truth. Behind this idea of truth is a conception of the universe. The totality of being or reality is intrinsically intelligible or knowable. There can be no universal knowledge or deep sense truth without this concept of a universe, and there can be no university without a universe and universal knowledge. So if we accept this model of universal knowledge as an ideal towards which the university ought to strive in all of its intellectual endeavors, then we can see how all the disciplines taught within the university ought, at least in principle, to bear upon one another. Newman argues that the various sciences arrange and classify facts, reduce separate phenomena under common principles, and trace effects to their causes. Inasmuch as sciences are forms of knowledge, they ought to be able to communicate with other sciences their results in order to contribute to universal knowledge. And it follows from this that each science then must understand itself to be incomplete without the other sciences in the university, and each must recognize the respects in which the other sciences are also contributing to the whole of universal knowledge. For Newman, the ideal university is a place of sharing knowledge, guided by the regulative ideal of the unity of knowledge, wisdom. For this reason, philosophy, the discipline which is especially concerned with the pursuit of wisdom, has a privileged position in Newman's ideal university. Ultimately, what Newman wants is for philosophical or universal knowledge to be communicated in every discipline. He argues that as we move towards philosophical knowledge of what we study, we can do this only insofar as we can begin to see how the different disciplinary truths are related to one another and how the truths they reveal form a unified body of knowledge that is consistent within itself. It follows from this that all university professors and students will need training in philosophy. I like this. Finally, I want to address Newman's account of what universal knowledge is for. Newman argues that the pursuit of universal knowledge helps to form certain habits of mind that he argues are essential to living well no matter what you do after graduation, and this is the greatest advantage of an institution that is truly devoted to liberal learning. And now I'll quote from Newman again. Students learn to form a habit of mind which lasts through life, of which the attributes are freedom, equitableness, calmness, moderation, and wisdom, which I have ventured to call a philosophical habit. This is the special fruit of the education furnished at a university. So knowledge here is not about power or progress or control. It is about the fulfillment of human nature and human flourishing. The contemplative habits of mind that a liberal education cultivate is good without qualification because it contributes to human flourishing. It fulfills the natural human desire we have to know and understand reality. It is this natural desire that is cultivated by a truly liberal education. It specifically directs it towards those questions that are fundamental and basic to human life, what we can know about ourselves and the world, and it seeks a universal account of them. I think it's necessary to stress that the pursuit of wisdom, as Newman outlines it, is essential to cultivating the interior freedom that is the foundation of moral and political life, otherwise known as human society. In order to live well and not merely work well or make the money necessary to satisfy your needs, we should be taking the pursuit of wisdom seriously. However, a merely technocratic approach to higher education, which is dominant, understands itself as a training for a life of work. It does this in a very explicit way. While such an education will always have a place in human society, a university education cannot be reduced to this and remain higher in any deep or meaningful sense. In its essence, higher education concerns the cultivation of the human mind so that students can become free. And I don't mean here, obviously, the mere freedom of consumer choice, which seems to be what many people in the academy do mean today. A truly free person knows what is true and good and beautiful, and therefore is free to realize his own potential and flourish. The liberal arts is ordered to the cultivation of this kind of interior freedom. Liberal learning proceeds from the commitment to the proposition that without such knowledge, you're not free. You're a slave to forces you don't understand. if all you have gained from the university is the sort of useful knowledge necessary for specialized work, including intellectual work and instrumentalized forms of reasoning, you will remain a slave to forces outside of yourself that you do not fully comprehend and are not equipped to do battle with. We may call this an education, but with what possible right would we call it a higher or liberal education? And so I think for me, as someone who's the inaugural dean of a college that is sort of self-consciously being constructed in the Newman ideal, I think that it's worth noting that the naysayers, the people who are constantly saying that students don't want to do this, it's false in my experience. And it's also interesting to note that although I am a Catholic, I've always been out in the wilderness, always in the secular academy. It is an ideal that appeals not just to non-Catholics, but to militantly secular people. And for that reason, I think it's an ideal that is still very relevant and worth pursuing. Thank you.
Thank you, Professor Frey. Father?
Too small for the desk, so I get to speak here. Thank you, Jeff, for introducing me, and thank you, Mark and Elizabeth, for inviting me. Please don't tell anyone that there was a priest talking to you here at the conference, because they might have a problem. It's a pleasure to speak with you today, and obviously, I'm by no means a legal scholar, and I feel that instead of myself, Matthew Levering should be here speaking about development of doctrine. I was rereading the conclusions of his book, an excellent book, Newman on Doctrinal Corruption, which is a wonderful book. And but I want to address to you some thoughts about this important topic of development of doctrine. And I'll say from the onset that I think Matthew, he discusses what dogma is in history and how it's understood today, and 5 or so interlocutors with Newman had, and the difference is the way he understood history and dogma. And another wonderful book, I think the 2 best books I've seen on the subject, is by Stephen Morgan, published by CUA Press, John Henry Newman and Development of Doctrine. And what he does differently. He analyzes how Newman came to the idea of development of doctrine, starting with the Vincentian canon, looking at that and looking at other things, and then looking at what the Church Fathers said as being the criteria, and others, and how he reaches the point. And I say this because I think what's lacking, and not because they're not capable of doing it, is a third book of saying, well, so how do what does Newman offer us? And obviously they do say this in this book, but that's not their purpose of each of these books. They have distinctive purposes. And hopefully either Matt or Steve Morgan will do that third book. I want to just shed some light on one particular practical approach towards the end of my presentation. Writing about the scriptures, John Henry Newman says, great questions exist in the subject matter of which Scripture treats, which Scripture does not solve. It is quite conceivable that an apostle might have dissipated them all in a few words had divine wisdom thought fit. But in matter of fact, the decision has been left to time, to the slow process of thought, to the influence of mind upon mind, the issue of controversy, and the growth of opinion. Well, this quote for me expresses the need for the development of doctrine taught or given in foundational texts. So there is this doctrine that we receive, either in Scripture or in the Constitution, that needs to be more fully understood. And we see in societies, in the history of societies, that there is there's been interpretation of the constitutional text. And now also we see the changes in theology and law, and due to many things such as social and scientific changes. So when we see these changes, we have to decide, are these changes developments or are they corruptions? After a brief introduction, I wish to examine the Supreme Court ruling on the subject of the non-establishment clause, Everson versus the Board of Education. And but I will briefly look first at the criteria that Newman puts forth in his book, The Essay of Christian Doctrine, Development of Christian Doctrine. And then I will refer to what he calls notes as tests. Initially he called them tests, later he decided to call them notes, but I think it's better to call them tests because you're very familiar with that word. At the end, I will examine or apply Newman's methodology to the question of school vouchers, just to help us to think. And that's what I think is maybe more interesting and practical. Jurists are commonly concur that we need to find continuity in the Constitution and case law, but they soon come up with conflicting principles, as was mentioned earlier, clashing principles. And justices suggest tests to resolve these conflicts. For instance, in the case, 1971 case Lemon versus Kurtzman on public funding for school books in Pennsylvania and Rhode Island, Justice Warren Burger offered the so-called Lemon test. This three-part test by which to judge future cases holds that to be judged as constitutional, a law must have a secular purpose, have the effect of neither advancing nor inhibiting religious practice, and three, that it must not produce excessive entanglement between state and church. I suggest that the tests identified by Newman, which we'll talk about in a moment and have been mentioned yesterday, provide elements for judging about the continuity or lack of continuity of a legal principle underlying a law, in particular when there are competing principles. As of June 2024, 29 states in the United States and Washington, D.C. had some kind of voucher system. Before these laws were passed, regarding other laws, there were competing principles that were found in judicial challenges to other laws concerning busing, purchasing of books, and use of school facilities. So going now to the 1947 decision of Everson versus the Board of Education, well, the Supreme Court found or overturned a ruling by the New Jersey Supreme Court, which found that paying for the transportation to private schools unconstitutional. In writing the opinion of the court, Justice Hugo Black maintained that the law did not violate the 14th Amendment due process to the state law, but in doing so, he favored or articulated a strict doctrine or a stricter doctrine of separation of church and state. The first argument was on the supposed unconstitutionality of paying for transportation in private schools. And Justice Black wrote, quote, "This argument, if valid, would apply equally to prohibit state payment for the transportation of children to any non-public school, whether operated by a church or any non-government individual or group. But the New Jersey legislature has decided that a public purpose will be served by using tax-raised funds to pay the bus fares for all school children, including those who attend parochial schools." End of quote. He also argued against a narrow interpretation of due process for those paying the taxes, I suppose, and he said, "Otherwise, a state's power to legislate for public welfare might be seriously curtailed, a power which is a primary reason for the existence of states." So the state had a business in helping students and helping parents. The second argument in the case was on the violation of the First Amendment, non-establishment of religion, and after providing a historical context of why that was of that amendment, he said, "The people there, as elsewhere, reached the conviction that individual religious liberty could be achieved best under a government which was stripped of all power to tax, to support, or otherwise to assist any or all religions, or to interfere with the beliefs of any religious individual or group. For Justice Black, the structure of government both preserves the government from religious interference and religious liberty from the evasion of civil authority. But to procure this, the court in Everson versus Board of Education, while allowing for payment of transportation, inclined, as I was mentioning, toward a stricter interpretation of the Establishment Clause. And he quoted that phrase of Thomas Jefferson, that the country should erect a wall, or the Constitution, a wall of separation between church and state. And that decision kind of was, according to a legal scholar I was reading, that was the tone of legislation for a few decades. Now, what we want to show here now is that this has changed, this way of seeing things, and but going back to Newman speaking about an inspired text, he says, "The question is whether those ideas which the letter conveys from writer to reader reach the reader at once in their completeness and accuracy on his first perception of them, or whether they obtain or they open out in his intellect and grow to perfection in the course of time." And well, his thought is that they do open up in time, and that you require time and thinking about this to see what the original text or revelation is saying. Professor Di Girolamo, in one of the texts that he showed me, comments regarding change in constitutional law, quote, "Change is vital because traditionalism depends upon new generations of participants in the practices of constitutional law to take what they have learned from their ancestors, to interpret and reinterpret those practices as craftsmen might in moving towards the telos of the perfected constitutional tradition." End of quote. As he has stated, there is a certain agreement today in jurisprudence that when we interpret the Constitution or texts, we want to follow in continuity with what the original text said and how it was originally interpreted. But again, as he mentioned, and there arise competing principles, and so when there's a competing principles for the interpretation, a given interpretation, then you have a difficulty. You say, well, where is the continuity? I think that a stronger case can be made for one interpretation or another when there are these difficulties, when in addition to the preservation of type and continuity of principles, two of the tests of Newman, the first two tests, when in addition to this, there are other tests in favor of one interpretation or the other. Excuse me, I didn't put those. So now let's mention the test that Newman, that Newman brings about. Newman, in his fifth chapter of Development of Christian Doctrine, mentions these various tests, and this is the way he puts it, and I prefer to read the way he says it. He says, "I venture to set down 7 notes of varying cogency, independence, and applicability to discriminate healthy developments of an idea from its state of corruption and decay as follows. There is no corruption if it retains one and the same type, the same principles, the same organization," which is really number 4, the same organization, "if its beginnings anticipate its subsequent phases and its later phenomena protect and subserve its earlier, if it has a power of assimilation," so this is out of order, "power of assimilation and revival, and a vigorous action from first to last." And then he dedicates the second part of the essay to talk about, to give examples and to talk about this. I think that these criteria, which we just enumerated. I'll mention something about them in a moment, but very briefly. These criteria can help us to think. They're not any ready-made answer that we can apply or test that we can apply, but they help us to think and to try to build a strong case for one interpretation or another. And but interestingly, people have often thought of these as retrospective. And I'm sorry, I'm making you dizzy with the changing of slides, but I apologize. So people think of these as retrospective, because number 6 and number 7 talk about judging what has happened to see if this interpretation that was given was right or wrong. So they think that the tests are primarily retrospective. And I will say that, and preservation of type and continuity of principle also are retrospective. We look. But I think the tests also provide some prospective or predictive way of considering different things. This is, for example, what Ian Kerr, a well-known Newman scholar, and some other gentleman by the name of Collins, or a theologian, they've given examples and developed them of how these tests can serve in a predictive manner. I've been thinking about the question of women's ordination, and I went through the test and I was looking at that slowly, and for me, I think it had predictive value to show that women's ordination to the priesthood would not be a good development, it would be a corruption. So I think that people will argue that even though some tests are retrospective, for example, number 1, number 2, number 6, and number 7, that as a whole they can also be seen in a prospective, predictive manner. If this were to happen, what would be the consequence? Now, applying these tests to the First Amendment and to the question of school vouchers to see if school vouchers violate the First Amendment, we want to consider, well, what is the First Amendment? And you know it well, but the Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. The non-establishment of religion, the first part, protects the choice and practice of religion and the freedom of speech. We will refer to the former, not the freedom of speech. But before going to this and applying to the voucher systems, we have to ask ourselves, well, what development are we talking about? What is this voucher system? What is it developing? What idea is it? And I would say, well, the idea is simply that you give the parents choose, and the government provides, or with taxpayer money, so the parents choose and provide for the secular and religious education of their children. So that's the idea, and so it doesn't sound like much of an idea or a new development, but it is an idea that parents choose and that that the government supports their choice. Now, a cursory application of the test to the school vouchers can show us the following, I think. So, as far as preservation of type, the first test that Newman mentions is that school vouchers support parents in the education of their children and in their exercise of religious freedom. And in doing so, it's no religion is established, so that parents are allowed to make their choice, and to act with religious freedom. And so it may seem that the government is, or some people are saying, well, you're supporting religion. Well, actually, you're supporting parents to make their free, informed decision. In the case Selman versus Simons and Harris that went to the Supreme Court determined that the voucher laws were constitutional, at least at the federal level. And the Supreme Court's majority opinion noted that the voucher funding was not being given directly to the schools, but instead was being given to the parents, so the parents choose. And since then, that has paved the way to a look at the voucher system from the Supreme Court. With regard to continuity of principles, which is the second test, we run into a problem. So we see on the one hand that there's continuity and there's that the freedom of religion in its practice, that's a principle that early on, although it was a difficult principle, but it was reached, that there should be religious freedom, although initially there wasn't, I would say. Second, non-discrimination for religious motives, and that is, I think, a principle that is inherent in the First Amendment. And then freedom of choice in education. They all seem the same, but I think there's something slightly different about each of those. And I would add that there's another one, that government support to parents for their children's education, or better yet, that the taxation benefits the taxpayers. So that there's a sense that Americans, we pay taxes, and so we expect that our money is used in ways that benefit us because we're paying taxes. So those are all principles ingrained, I think, in large measure in our country. But we find that there's a competing principle, and maybe more than one, but that of separation of church and state, and which for some would say, well, that argues against school vouchers, because then you're supporting a school, they will say. As we saw in the Lemon test, this is called also principle of non-entanglement. But now, in the face of conflicting principles, well, we need to consider other tests, precisely because they will help us to break the tie, so to speak. If there was a tie. I don't think there's a tie, but they would help us to break a tie. So I think that the Newman on development will help us with this, and when he talks about logical sequence, Newman means the organization of a body of thought. He doesn't mean pure logic. And he says it the following way, briefly here. He speaks of a sequence. It says, an idea under one or other of its aspects grows in the mind. By remaining there, it becomes familiar and distinct and is viewed in its relations. It leads to other aspects, and these again to others, subtle, recondite, original, according to the character, intellectual, and moral of the recipient. So he's talking about, when it's logical sequence, that there's a body of thought and an understanding. And here's where one would say that that parents being able to choose where their children go to school and help to pay for that school, this is in keeping with helping parents to exercise their right, their freedom of religion, and so that it's part of an understanding of a wider understanding, a more fuller understanding of that idea of freedom of religion and so that it's a development of the First Amendment that fits with the tenor of the First Amendment of the free exercise of religion. Anticipation of its future, I would say that this First Amendment anticipates the existence of schools which offer different religious principles, precisely because no religious group has a monopoly on schools. When Newman started the medical school in Dublin, which continues, the medical school in Dublin, what he did is thank you. What he did is he saw there was a monopoly of Protestant doctors, very few Catholic doctors, so he wanted to break the monopoly. Okay. There's other principles that Newman invites us to think about, and basically what I wanted to, even though it was very brief and pointing out to this at the end, was I think this is something we need to consider and think about, and there's no easy way of coming to a conclusion, but Newman helps us to see that when there's a competing principle, you look at other tests or other tests that aren't here, and you try to come to some conclusion. And so I think what Newman says has value in law and other areas besides theology. Thank you.
All right, well, thank you, Father. Thank you, Professor Frey, for your excellent remarks. I'll close up here. I do want to start by noting how happy I am to be here, especially the occasion of of Mark's chair. Professor DiGirolamo is one of the most engaging, thoughtful, learned, and interesting. Interesting is an overused term, but I think it's richly deserving here. Scholars in the legal academy. He's also one of my dearest friends. So he richly deserves the honor of this chair, and it's great to play a small part in celebrating it here. So when one thinks about the relationship between Newman's thought on the development of doctrine in the church and the development of legal doctrine, it's actually really hard to know where to begin. There are so many potential parallels and fruitful avenues of inquiry, but also worries about superficial resemblances and imperfect analogies. This is all the more challenging for an academic lawyer like me, who's neither a trained philosopher or a theologian, but it's all the more challenging because Newman's work on doctrinal development is complex, it's subtle, and it's also hotly contested. Different theologians interpret Newman in such different directions makes it all the trickier for an interloper. I can't help but feel I'm trying to build the ship while I'm at sea. But luckily, I've got some good anchors here, including some of our participants here. So Professor DiGirolamo's work on tradition and law in general, and constitutional law in particular, provides an excellent focal point for my remarks. And in educating myself a bit in preparing these remarks, I profited greatly from Professor Levering's book on doctrinal corruption, and Professor Tracy Rowland's chapter on the development of doctrine in Father Vélez's recent compilation. So Rowland contends that Newman's work served as a crucial via media in Catholic theology between intellectualism and historicism. Theories about legal doctrine have similar dangerous terrain. First, consider intellectualism. Scholars of private law will be well aware of philosophies of tort, contract, and property that drink deeply of Kant's philosophy of right or Hegelian understanding of personhood, but treat messier case law as unfortunate dregs at the bottom of the glass. Rationalist theories of constitutional law also abound, as we observe Ronald Dworkin's Hercules and his judicial imitators, laboring to make the Constitution the best it can be in light of abstract political morality. Historicism also abounds, especially in pragmatic legal theory. For all their differences in other respects, legal realists and descriptive doctrinal scholars alike in private law regard the common law as contingent developments directed by forces of history and general intellectual trends. Much the same can be said for constitutional law, including by originalists of the legal positivist variety who think the domain of law is limited to rules and conventions that we happen to have. There, in the legal domain at least, all that succeeds is success. One might note provocatively here that some forms of legal traditionalism are particularly susceptible to the risk of historicism. One of the early leading theorists of the common law tradition was David Hume, whose conventionalism is well known. Classical common lawyers often had a kind of ambivalence about natural law, leaving it to lie at the subterranean level, and feeling much more comfortable talking about whether law is suitable to the ways and practices of particular people, and nothing more. More contemporary theorists of classical common law thinking like Brian Simpson and Gerald Postema also focus on convention, shared reasoning, and local particularity. And if one reads Martin Krieger, the excellent Australian philosopher of legal tradition, it is hard to find anything but tradition as the fundament of law. To echo one of Professor Levering's questions, could there be any standard for corruption if all that succeeds in tradition is historical success? So the specter of relativism hangs over this kind of approach to traditionalism. Professor DiGirolamo, as a natural lawyer and non-relativist, would surely like to avoid that. And his theory of traditionalism and constitutionalism does that. There is, as he said in his remarks earlier today, some space for the critique and replacement of bad traditions, with bad meaning objectively wrong as a moral matter, not simply unpopular. But how does one find a via media here in law? I think it's important to note here that merely transposing Newman's 7 notes of doctrinal development to the legal context might not be enough. Certainly, they're illuminating aids for seeing how a body of law can be coherent within itself, how a tradition can grow in an organic fashion rather than sit frozen in amber. It can provide a measure internal to the body of law itself of doctrinal development or corruption. Any student of ordinary doctrinal legal science would benefit from seeing how Newman's 7 notes characterize the development of doctrinal tradition. But tradition for Newman was not enough. Presumably, one could use the 7 notes to track the development of Eastern Orthodox or Protestant doctrine, or the development of halakha, or particular teachings of Islamic schools of jurisprudence. That fact would not lead Newman to assent to those teachings. Tradition, as Newman understands it, seems crucial for building a mode of thought that is an alternative to deductive rationalism or idealism, but is not sufficient unto itself. Non-historicist legal theorists who value tradition, then, need something more. It's therefore worth briefly considering the other building blocks in addition to tradition that Professor Rowland notes in her chapter on Newman. She identifies three others besides this organic account of tradition. First, there's an historical account of revelation. Second, an understanding of the teaching office of the Pope and the Ecclesia Docens more generally. And third, conscience. I'll focus on the first two, although all are important. As we're thinking here, kind of essaying out to think about analogies in the classical sense of the term. First, revelation. Newman does not value tradition for its own sake, but rather for the way it can help reveal a deposit of faith that has always existed but becomes clearer in the fullness of time. If we're going to transpose the development of legal doctrine, especially constitutional doctrine, into a Newmanian key, if that's a word, it is worth wondering whether there's a legal analog to revelation and what it would look like. This raises very important questions that I can't easily answer, but here's some things worth considering. And we need to be careful here, lest we slide into a kind of legal idolatry. Nevertheless, if the development of legal doctrine is to avoid just being the story of one thing after another, there needs to be a measure of doctrinal corruption more robust than internal coherence. One natural candidate is, of course, the natural law. I believe in natural law and think all human law is answerable to it, and so does Mark. The natural law directs but leaves unanswered many important questions of human affairs. And while this suggests the natural law can provide inspiration for and a salutary check on the development of tradition, it also seems to present risks for understanding natural law alone as the anchoring source of human law's magisterium. Let me explain. My worry here is that it does seem odd to suggest the development of our contingent legal system is the revelation of natural law over time. This is so even if the legal system is entirely compliant with the natural law, which we know underdetermines many legal questions. It may be plausible to say our Constitution, ratified in 1789, in some sense provided the seed for the Supreme Court's doctrine of removal of executive officials in a fashion analogous to the way the magisterium always contained, but had not yet articulated the Assumption of Mary. It would be strange, however, to say the natural law contained the seed of such officer removal doctrine, especially since many just constitutions have no such provision. To put it another way, it's not so easy for Catholics to say the Immaculate Conception was one of many reasonable options for revelation, in the way that you can say about the contents of Article 2, Section 2 of the U.S. Constitution. A more fitting analog for revelation here might be a kind of foundational document, or if we're in a country without a written constitution, statutes and fixed practices of equivalent status. A tradition that departs from that original fixed lodestar law is doctrinal corruption, which is the measure and starting point of any tradition. We can put it in originalist terms for the lawyers here. Doctrinal development can occur in the construction zone, but cannot replace interpretation of original norms. I suspect Professor DiGirolamo would resist this, though his theory does have a proviso saying that traditions cannot depart from the clear text of the Constitution. But I also wonder if Newman and the Fathers of Vatican II would resist this analogy as well. This analogy views human law and its revelatory analog as a kind of propositional information contained in a canonical document, and its separate source of tradition whose teachings are somehow contained in Scripture. De Verbum, however, treats Scripture and tradition as interpenetrating each other and working together as the living revelation of Christ himself in our world. Undertaking sublunar civil law in those terms, however, is trickier. Taking the analogy too seriously risks treating all human law as the unfolding of some kind of divine plan, and thus either ignores or gives little explanation for human law's well-known and crucial variety. Or it suggests a kind of legal polytheism where each system has an eternal essence revealed in the fullness of time through exact legal science. And I know Mark doesn't want to go back to the most exotic branches of the historical school of jurisprudence in its discussion of national essences and the like. So either we need to think more and better about human law and how it can relate to revelation in our adaptation, or perhaps we need to conclude that translating Newman to this context requires a humbler understanding of a doctrinal anchor. And if it's the latter, we might need something more fixed if tradition and development are to be more than just change over time. Second, there's Newman's understanding of the role of the Pope and the Ecclesia Docens. Although Newman rejected the strongest versions of Ultramontanism on offer, he gave an important role to the Holy Office as an authoritative developer of doctrine, a crucial custodian of tradition that helps manifest revelation, if you will. So, some common lawyers would readily agree, though focusing more on the learning of the 12 men in scarlet who used to supervise the king's justice. As Brian Simpson wrote, a traditionary system can function only if it can preserve a considerable measure of continuity and cohesion, and it can only do this if mechanisms exist for the transmission of traditional ideas and the encouragement of orthodoxy. If the development of Catholic doctrine, at least, the papacy plays an important, if contested, role. Professor DiGiolami's work on constitutional tradition pays some credence to such a need. He does not argue for a kind of popular constitutionalism in which the courts in general, and the Supreme Court in particular, get entirely out of the way and allow the people to govern themselves through their own organic traditions alone. The Supreme Court's role for Professor DiGiolami, however, is somewhat ambiguous, I think. The primary driver of determining traditional constitutional meaning, or content now, under his theory, is popular practice. The role of the Supreme Court, then, is to identify and recognize authoritatively the popular practices that are presumptively authoritative for the meaning or the content of what our law is. One can't help but reach for sensus fidelium analogies here, as Mark anticipated. I wrote that before I heard that. But the Church doesn't treat sensus fidelium as the same thing as majority opinion or popular custom. As Pope Francis said in his 2023 address to the ITC, for authentic expressions of the sensus fidelium, there needs to be a disposition of participation in the life of the Church, listening to the Word of God, openness to reason, adherence to the magisterium, holiness, and seeking edification in the Church. As Rowland points out in her chapter, for Newman, it is the saints who embody the sensus fidei in its highest power, and especially the saints who stand out among the Church doctors. If, for the lawyers in the room, we're going to draw a crude analogy, sensus fidelium looks a lot more like the constitutional doctrine of liquidation, where prominent members who are faithful to the Constitution seek to settle through argument and reasoned decision the meaning of an uncertain provision, not the more populist, practical construction we see in Marx's legal traditionalism. Now again, law is not theology, and the Constitution is not our Lord's revelation incarnated on earth, although you might be mistaken for that in some constitutional law classes. It is possible we need to adjust our analogies accordingly. And if we do, there could be difficult questions about what a system that hangs together well in Catholic theology can tell us once we alter the dimensions of some of those building blocks. In any event, the parallels and resemblances between these two systems of development are too striking to ignore. Nevertheless, if we're going to discover what Newman's development of doctrine can teach us about law, we might first have to answer important threshold questions about the nature and relevant similarities between human law and revelation, the proper way of reading those texts, and the constitutive role of the people in the city of man versus the city of God. Those answers will take far more than one person with 15 minutes to provide, but it sounds like a very fruitful research agenda for a community of Catholic legal scholars and students. I'm clearly in the right place to raise these questions about Newman and the law, and Catholic University's Columbus School of Law could not have picked a better eponymous chair to lead the pursuit of those answers. Thank you. So, how are we on? How are we on time? What time do we?
Have about 6 minutes.
Yeah, let's move to 5. Yeah. Someone with a mic. Yeah.
Hi, thank you very much. I have a question for Professor Frey, which I really very much enjoyed your talk. I now know who I have to blame for the fact I haven't seen any wisdom in 30 years in the university. It's Weber's fault. I didn't realize it was his fault.
All goes back to Weber. Occam and Weber. You know.
Everyone's allowed to hate Weber.
My question, though, is I think there's a third model of the university I wanted you to comment on. It seems to me in America, at least since World War II, a major model for the university is social mobility. It's been the ability of universities to reach out to populations and raise them out of their particular social setting and move them to a different social class. That seems to be a really important argument for universities in our world, in our culture. And I wonder how that would fit into your theory of the university.
Yeah, so thank you for that question. That's a wonderful side effect of our universities, but it cannot be the telos of our universities. Universities have been responsible for social mobility in my family for 2 generations now, but it cannot be the goal, right? I think that, and I think whether it continues to do that in the future is very much up for grabs. But which isn't to say that that it would be better if it weren't doing that. It's just to say that those trends post World War II are not continuing. But I think, really, so I've recently been reading a lot of histories of the university generally, but the American university in particular. And really, I think the most dramatic effects of revolutions and higher education in the United States post World War II really have to do with the structural changes that we see in what it means to be a research university. So every university in the United States was originally a college, a small liberal arts college. They become universities, research universities in the late 19th century or early 20th century. But what happens after World War II in particular, and it begins at the University of California, Berkeley, is this idea of metrics, right? This is when the Carnegie research system comes into being, that we can bureaucratize and institutionalize metrics and sort universities into categories, R1, R2, liberal arts, and we evaluate universities based on completely functional metrics, right, that we can quantify. That too is very much in the Weberian mold, and I think for a while it was responsible for legislators dumping lots of money into these institutions, but I really think it's an open question whether this model continues to serve that function going forward. I don't think it's doing it as well right now, for example.
Can I ask a question about I'm having some difficulty mapping Newman's thinking onto the school voucher situation, because it strikes me of an example of something that I see a lot in law practice, which is the premise of Newman's thinking, as I understand in terms of development of doctrine, and the church's thinking, is that the church is unfolding something in the deposit of faith that was always there, but perhaps not made completely explicit. Whereas oftentimes what we encounter in, say, First Amendment cases, for example, are practices that have no relationship to the founding whatsoever and developed at various points, and now we need to try to reconcile them. And the school vouchers case, I think, is a good example where modern public education has no founding era analog. Nothing like it existed at the founding. The restrictions on aid to religious people in religious schools were a function largely of 19th century Catholic immigration and not liking Catholics having their own schools. And then you have the lifting of some of those restrictions as a function of integration into the mainstream that happens after 2 world wars and the GI Bill. So how do we think about, are we really vindicating principles or concepts that were always there if there were these various practices that just came up along the way? Is that really the same to what we're doing?
Well, I'm glad from what that Professor Pojanowski made distinctions, and there's analogies and his own work and the similarities. I still think his thinking about his methodology can be helpful. And referring to you, well, yeah, that's I hear what you're saying. I want to think about it more, but basically inherent on the rights of people, for example, the right to practice of religion, those are things that are foundational. And when the Constitution was written, or the Declaration of Independence before that, these men were thinking with ideas of natural law, varieties of natural thinking, natural law, but they were so, and so they understood the human person and rights of the human person, dignity of the human person, which certainly, even though I would have to see how clear they were on religious freedom, but nonetheless, it's something that already was there, because you're talking about how you organize a society, how you respect people's rights. So it was inherently there. Although I still think there's great dissimilarity. I'm just using it as a possibility, something that can intersect between law and theology and be helpful.
And I think, and even in a kind of more prosaic sense, there's a sense in which you can have, you can the Constitution in some sense can answer questions that the founders never even thought of, right? So, those Fourth Amendment cases where the police are like using like infrared rays to look into your house, and is that a search, right? And if you were to ask, James Madison, what do you think about infrared rays? He'd be like, what are those, right? But there's a sense in which you can say without being fictitious that there's a sense in which, yeah, we know that's a search. The Constitution hadn't, it contains that answer even though we never thought of it. And it also seems like similar to the idea, like if you say something and someone says to you, oh yeah, and so that means you also believe this. By saying that, you impliedly also think this. Like, yeah, I hadn't thought that, but yes, I did. And so there's a way in which kind of texts and statements can kind of contain answers that weren't presented. And that may be kind of an analog to development. Yeah, they didn't have public schools in the 19th or 20th century, but the principles may be there. And we can kind of apply them in this particular context. You can have development along those lines.
So I think we have time for one more question for Professor Martin.
Thank you. I see we're out of time, but I just wanted to kind of address this issue that William brought up as well. I think there's a sort of overwhelming sense that Newman's metaphors are organic entirely, but I think if we read Essay on Development, they're not always organic. They're also dialectical, right? There's like heresies force the church to clarify and outline and define, right? No doctrine is defined, he says, until it's violated. And so I think that can be a way of thinking. We don't have to think exclusively in these organic metaphors. We can keep Newman on the table precisely because of these kind of dialectical things that only happen because of the contingencies of history and progress, right? So I think that's really helpful to include. So.